Welcome to this explainer. Okay, let's dive right into this. Today we're taking a deep dive into how one single poem triggered an absolutely massive Cold War censorship battle. We're going to look at the historical and legal earthquakes surrounding the publication of Allen Ginsberg's famous poem, Howl. It's this incredible story about art, obscenity, and the exact moment when American culture just began to shift right beneath the feet of the establishment.
So, to really understand how we got here, we kind of have to drop right into the action. Picture this. It's late May 1957, right in San Francisco's North Beach district. Officers Russell Woods and Thomas Page of the SFPD's Juvenile Division walk straight through the doors of the City Lights bookstore. Now, they aren't there for some light reading. Nope, they immediately arrest the clerk on duty, Shigeo Shimuro, for distributing obscene material, specifically Ginsberg's Howl and other poems. A couple days later, the bookstore owner and the poem's publisher, Lawrence Ferlinghetti, gets back from a trip to Big Sur and surrenders to the police. The sheer scale of the stakes here, well, they literally cannot be overstated. We're not just talking about a single book of poetry. Even before the trial got underway, Captain William Hanrahan of the Juvenile Division made the department's intentions crystal clear to reporters. Get this, he declared, anything not suitable for publication in newspapers shouldn't be published at all. The police fully intended to use Ferlinghetti's arrest as step one in this sweeping, citywide campaign to wipe out what they considered filth from local bookstores. So Ferlinghetti, who was really just trying to build an intellectual community around his shop, was suddenly dead center in the crosshairs of the law.
Act 1. The Juvenile Delinquency Panic. Now, to truly grasp why a book of poetry became a matter for the Juvenile Division of all things, we've got to zoom out for a second. Think about the deeply paranoid cultural backdrop of the 1950s. In that decade, right after World War II, America was in the grip of this massive moral panic surrounding juvenile delinquency. And the censorship crusade, it was overwhelming in its scope. You had law enforcement, journalists, and even Congress, like Senator Estes Kefauver's Subcommittee on Juvenile Delinquency, traveling the country, investigating how all these different media targets were supposedly corrupting the youth. I mean, they were looking at everything. The connection between street gangs and narcotics, the violent content in comic books, the sexualized lyrics of rock music, motion pictures, pornography, the whole shebang. Just listen to this claim from the era. Every proved delinquent has been definitely influenced by rock and roll. It's wild, right? But it perfectly captures the mindset of authorities back then. Leaders genuinely, truly believed that cultural materials were direct catalysts for juvenile crime. Some even went as far as to suggest this was all part of a grand communist conspiracy to destroy America's youth. To them, impressionable young minds were literally being afflicted with abnormalities just by what they were reading, watching, and listening to.
Let's move to Act 2, a legal turning point, and see how this builds. So while local police and politicians are trying to crack down on all this culture, the federal courts are doing something completely different. The legal ground was actually shifting right beneath the prosecution's feet. Courts were starting to interpret the First Amendment way more broadly to protect controversial expression. Back in 1948, the Supreme Court stopped a local campaign to censor comic books because the laws were just too vague. Then, in 1952, they extended those First Amendment protections to motion pictures, striking down a ban on a film that was labeled sacrilegious. And then we hit the summer of 1957. This is the exact same summer Ferlinghetti is standing trial in San Francisco, and the Supreme Court hands down a massive, game-changing decision on obscenity in a case called Roth v. United States.
That decision created what we now call the Roth test. The court basically ruled that, sure, obscenity was still illegal, but there was this one absolutely crucial exception. It protected expression that contained ideas with even the slightest redeeming social importance. And yes, that included unorthodox, controversial, or even hateful ideas. So what's the big takeaway here? This brand new 1957 ruling created the exact legal threshold that the entire Ferlinghetti trial was going to hinge upon. The prosecution couldn't just prove Howl was indecent anymore, they had to prove it lacked any redeeming social importance whatsoever.
Act 3. The Courtroom Crucible.
Okay, so with that new legal standard in place, we head back to the San Francisco District Court. It's late summer 1957. Presiding over the case is Judge Clayton W. Horn. Now get this, he was a Sunday school teacher who had recently forced shoplifters to write penitent essays after making them watch the movie The Ten Commandments. The legal strategies clashing in his courtroom couldn't have been more different. Leading the prosecution was Assistant District Attorney Ralph McIntosh. He actually described himself as a specialist in smut cases. His strategy? Simple. Isolate all the graphic, arcane language about sex and narcotics in Ginsberg's poem, read it completely out of context, and just shock the court. But on the other side, defending Ferlinghetti completely pro bono was Jake Ehrlich, a legendary attorney literally nicknamed the Master. Ehrlich's strategy was to tackle the Roth test head-on. He flooded that courtroom with prominent academics, journalists, and writers to definitively prove the poem had real social value. And this brilliantly illustrates the defense's entire approach. The prosecutor was aggressively questioning their star witness, this prolific UC Berkeley scholar named Mark Schorer. He's pressing him on what these specific, graphic phrases in the poem literally meant, and Schorer just calmly replies, "You can't translate poetry into prose. That's why it's poetry." Boom, hit the nail on the head. The defense effectively used these academic experts to argue that Howl wasn't just obscenity, it was a powerful indictment of the modern world and a deeply significant commentary on the human experience. Now, the prosecution's witnesses, they really struggled to meet the burden of that new legal standard. Take a look at this reaction from Gail Potter, a high school speech teacher called to the stand. When asked to evaluate the poem, she flat out testified, "You feel like you are going through the gutter when you have to read that stuff." And that was kind of the prosecution's whole problem. Their witnesses were just equating redeeming social value with their own personal distaste. They didn't like it, so to them, it obviously had no value. Act 4. The Verdict and Legacy. After this incredibly contentious summer trial, Judge Horn actually took a full month to formulate his opinion. You can imagine the tension in San Francisco's literary and legal communities. It was absolutely through the roof. Finally, in October 1957, he hands down his landmark ruling. Judge Horn found Lawrence Ferlinghetti not guilty, ruling that he had every constitutional right to publish Howl. He leaned right into that new Roth test and declared the poem absolutely possessed redeeming social importance. But he actually went even further than that. Judge Horn stated that in a free society, the only truly democratic way to control publication is through the individual choices of the public. Basically, let public opinion do the censoring, not police raids and the government. This verdict revealed a profound, massive cultural shift in America. The conservative establishment was suddenly finding itself completely out of step with these expanding definitions of free expression. A couple of years later, reflecting on his loss, prosecutor Ralph McIntosh said something incredibly revealing. He said, "There was no one behind me. The court was full of beatnik types. I felt lost." It really shows how he and his allies felt totally alienated from the rapidly changing cultural landscape that was just blossoming right in front of them. So what happened to Ferlinghetti, Ginsberg, and the rest of the Beat generation? Oh, they completely embraced the controversy. The trial handed them massive national cultural exposure on a silver platter. Instead of suppressing the poem, that police raid turned Howl into a massive bestseller and transformed City Lights bookstore into an absolute cultural landmark. The Beats basically used the censorship attempt as a giant megaphone. They proved that trying to officially regulate speech in Cold War America was starting to seriously backfire. Which brings us to a really provocative thought to wrap up this explainer. Judge Horn made it clear that the government cannot legally censor this kind of art. But, the debate didn't just magically end there. It really just shifted from the courtroom straight into the public square, as critics continued to publicly censor the Beats in magazines and newspapers. So what is the fundamental difference between legal censorship by the state and public censoring by the culture itself? And how exactly does a society regulate controversial ideas when the government is legally barred from doing so? It's a huge question, and honestly, one we're still trying to figure out today. Thanks so much for joining me on this deep dive, and as always, keep asking questions.